Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Obviously, we are on the road today, but there's still two big stories we need to talk about. First, Judge Boyce issues a ruling on Lori Hellis's motion to unseal the documents and to intervene in the case. We'll talk about that. And then at least one of those judges believes on erring on the side of releasing information for the public as they have a right to know. Let's talk about it. Good day, Crime Talk aficionados. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and remember you can listen to us on any of your favorite podcasting apps. As you can tell, we are on the road today. You may say, what exotic location are you traveling to today, Scott? And does it involve something with Four Seasons or the Ritz? Well, no, it doesn't. I am in Alamogordo, New Mexico, a beautiful place indeed, but it's not exactly known for a lot of the tourism. But my son is stationed here, and he is graduating. He's going to officially be able to, fly that F-16. Well, he can already do it by himself, but I guess maybe he can bring it home on the weekends. Maybe let his dad take it for a spin. I don't know. So I'm down here for that because, well, I'm pretty proud of him. And it is my daughter's birthday as well today. Big day. So anyway, we're on the road. So let's get to the top stories. As you may recall, Lori Hellis, who was on our show, we had her on our show. We talked about the motions that she filed in the Lori Vallow, Chad Daybell matter, because she was really concerned that everything was being sealed and not being released to the public. And normally in criminal cases, things are released to the public. Yes, we're not going to get the discovery, but it seems like everything in the Lori Vallow case and Chad Daybell case, is just about, it's all sealed. Everything is in private, and you can't get access to it. And that is very, very unusual. So Lori Hellis, who is a retired attorney, filed three motions with the court. The first one was a motion to intervene, a motion for injunctive relief, and a motion to unseal all documents and transcripts for the recordings and hearings. Now, Judge Boyce, in a very, I wouldn't say condescending, but basically says, if you only knew how our rules here in Idaho, Ms. Hellis, you would know that you can't do this. I took it as kind of condescending. But it says the record indicates that Hellis is pro se. In Idaho, pro se litigants are held to the same standard as attorneys. Duh, everybody knows that. So then the judge jumps to the motion to intervene. Hellis cites to the Idaho Rules of Civil Procedure 24 and Idaho Court Administrative Rule 32 as authority to intervene in a criminal case. In addition, Hellis claims standing due to her status as a media member and credentialed author. As more fully explained, the court finds the motion both procedurally and substantively improper. Now, interveners may occur in civil, not criminal proceedings, as indicated by both the absence of a corresponding criminal intervention rule and as determined by Idaho case law. Now, remember, ladies and gentlemen, the public has a right to know, and the press can file something with the court saying, please, we want to record these proceedings. Ms. Hellis files a very well-written, I thought very well-reasoned analysis as to why she, as a member of the public, should be allowed to see these documents and saying, hey, Judge, I want to formally intervene. Look at me over here. The court says, we don't even have that in criminal proceedings. I get that. That's true. That's the way it is in most criminal proceedings. But guess what? When the rules are silent on the rules of criminal procedure, then you look to the rules of civil procedure. Then you look to the rules of civil procedure for guidance. And that's what Lori Hellis did. But the judge basically said there's no mechanism for non-parties to intervene in criminal cases, and therefore the motion is denied. The court then goes on and addresses the issues made under Rule 32 and basically says, once again, denied. The court finds Hellis' request as pled fails to honor many of the policies set forth in Rule 32, which includes providing express procedures for the public to obtain court records that makes the most effective use of the court and the clerk's staff. and avoids unduly burdening an ongoing business of the judiciary. And Rule 32 does not permit interveners in this case, and for that additional reason, the motion to intervene is therefore denied. I mean, I just think the tone very condescending here by Judge Boyce, but that's just me. That's just the way I read it here. And then the final motion for injunctive release. The second motion, Hellas's second motion for injunctive release says that Hellas' second motion is a motion for injunctive relief. The court first notes that even if Hellas were a party in this case, a demonstration of standing is a prerequisite for obtaining any such release. In order to have standing to seek injunctive relief, a plaintiff must demonstrate a likelihood of repeated injury or future harm to the plaintiff in the absence of the injunction. Then once again, he says, but she's just an intervener, and in this motion sets forth the above has no right to intervene in the criminal case. And so can you imagine what the court says? Yes, that motion is denied. The court then goes on to state regarding the unsealing of records that says that on August 6th of 2021, the court entered a public order in this case directing that all subsequent pleadings in the case be filed, captioning only the individual defendant's respective case number and name. While the order is expressly directed to counsel, the intention of the court extends to any person attempting to file pleadings in either case contemplated in this order in order to maintain a consistent, orderly administration of the case. However, should Hellas desire, she may comply with the order as well as the Idaho Court Rules 2.3A4 and refile the motion or motions requesting the unsealing of records, at which time they will be considered by the court. If refiled, the court directs Hellas to identify which specific records, transcripts, or hearings are requested to be unsealed as they relate to each distinct case. Further, upon refiling a separate motion, the court will thereafter designate interested parties in each individual case. See Idaho Court Rules 32.1I1. Upon the court's designation of interested parties, Hellas must thereafter provide proper notice to all interested parties pursuant to the rules. Upon certification that proper notice has been provided, the court will and then schedule a hearing and request the unsealing of records in accordance with the rule and in order to satisfy due process and allow all designated interested parties an opportunity to respond to the request. Therefore, the motion to intervene, denied. The motion for injunctive relief, denied. And Hellas's motion to unseal, denied. But that's without prejudice. She can try again if she could get her captioning down correctly. Are you kidding me? This is a classic example of form over substance. Okay, Judge, you're not going to allow her to intervene. You're not going to grant her injunctive relief from having the next hearings sealed. But now, if you could get it possibly correct and you dot your I's and cross all your T's, then maybe we'll have a hearing if proper notice is given. And if you let me know exactly what you're looking for, then we can help. Well, hey, Lori Hellas, let's chat. Let's see what we can do. Let's see if we can coordinate this. We want it all, okay? We want it all. I'm telling you, this is why people don't trust the government. This is public information. These are public records. And when the public has to fight to get copies of what they are entitled to do under their own rules, then they create all these little rules that you have to jump through hoops backwards with bells on just to see if you can actually make your way through the legal maze. And you wonder why people don't have trust in the system. Really, Judge? Form over substance. That's what that order is all about. Doesn't say you're not entitled to the stuff. Just says, the way you went about it just isn't right. So therefore, come back and try again, you little peasant, Miss Lori Hellas. Come back and try again. Unbelievable. Next on the docket, that's right, search warrants, access to public records. At least somebody, one judge, and frankly, I'm not going to lie, I was a little surprised that the magistrate judge originally granted the motion to have the search warrant at Mar-A-Lago. I was surprised that he even entertained the notion of the motion filed by the press. Once again, it's the press that's coming forward to say, we want access to these public records. U.S. Magistrate Judge Bruce Reinhart, who signed off on the original search warrant for the August 8th raid, put off the final decision whether to put out the document, which media outlets and allies of former President Donald Trump were seeking following the extraordinary raid/search and seizure, however you would like to define it. Judge Reinhart told the government to come back with proposed redactions after Justice Department officials argued that putting out information on witnesses could hamper future cooperators or endanger those who were providing information. The judge also made comments suggesting he would weigh in favor of putting out additional information as media organizations are seeking, which is good. We're entitled to this. This is a huge case of public interest and is an opportunity where everybody gets to see how the Constitution works. And we're going to find out by that affidavit. Was the Justice Department playing games? Was the Justice Department trying to get cutesy with saying, oh, we're going to do this? Because we found out that the Attorney General pondered this for 2 weeks, whether he thought it was appropriate. Well, I would think if nobody's above the law, we should go and do it right now. We've got the documents. Let's charge somebody if they're going to do that. Or did they get too cute? Or we're going to find out if Donald Trump wasn't playing, in accordance with the rules either. If they're asking for the documents back, give them back. Make a copy and give them back. But give them back if you don't have to have them. Maybe there's a legitimate dispute. Okay, but somebody is not telling the truth, and the American people are entitled to know. So I'm glad Judge Reinhart has said he's going to entertain it, and he will probably have redactions of the affidavit. Okay, fine. Take out the name. We can probably figure out who that is anyway, but we don't need paragraphs or pages completely blacked out and redacted on this affidavit. Listen, if the government is willing to go execute a search warrant, that means they're getting ready to probably file a case, and therefore this information would come out eventually. So we have a right to know. The member of the public has a right to know, and at least the press believes so in this case as well. And frankly, I was a little skeptical that Magistrate Judge Reinhart would entertain such a request, since the government was saying, no, don't release the affidavit because, there's danger, scary danger. Witnesses could be put in grave danger. I don't think so. I've been doing this a long time. And listen, we're talking espionage documents. I don't think you need to worry about people's livelihood or their endangerment for a case like this. We're not talking organized crime. We're not talking gang members who are going to go retaliate against the snitch. It's not going to happen. So now we have another week to wait, but hopefully the government in this particular case says, give me a redacted document and we'll see what we can do. He could have done a Judge Boyce and said, oh, you didn't follow the proper form. You can't intervene. You can't request to be here. Come back and try again. I think it just shows you a little bit of the difference between federal judges and state court judges. Just saying. Particularly a new one. All right. That's all we have for you today. Thanks for watching. We'll see you next time. And I'm enjoying my son's graduation. We'll talk to you tomorrow.